Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. I couldn't do a live recording this Thursday because of some other commitments, plus the fact that the Thursday was a Veterans Day. But I'm recording the call, and we might have to miss one more call during December. I think I'm not exactly sure what the reason was, but the team had told me that we would be missing one. So here are the answers to today. First, we'll go over the frequently asked questions. So here is one about qualifications for EB1 multinational executives and managers in a small company. Just as a beginning note, it is definitely more difficult to process EB1s or L1s for smaller companies simply because the size of the company can often be instrumental in setting out how many people somebody supervises. Now, you could, of course, be a functional manager, where you don't manage people, but you manage a function. For example, you are the CFO, you are the chief financial officer, you don't have any reportees, but you set the fiscal policy for the entire company. So that's an example. The question here is, I'm a senior developer, small company, 15 employees, privately held, I have no stake. That's fine. So my I-140 is approved under EB3. I can start a team in India for my current company. I can manage the team staying in India for a year and come back to US and still manage the Indian team. So there are two issues here. One is, does the team being managed in India from the United States count when we compute the number of people you supervise, which is one of the issues for EB1, L1 type cases? And the answer is yes, we should be able to. And I think we have covered that in last discussion, last community conference calls, questions in great detail. It's also posted on my blog, I believe, no, in our frequently asked questions on immigration.com, as well as on my author page on the Economic Times. So if you just Google Rajiv S. Khanna, or Khanna as they say, Economic Times, you'll come to my author page, and I have answered this frequently asked question. So you should be able to use that team. You might be eligible not after 3 years, after 1 year. You don't have to be outside the USA for 3 years. It would be done after 1 year. So there is a way this can work. Have a detailed consultation with your lawyers, work out the kinks, but this can definitely work. Okay. So next question, another frequently asked questions. Can I use an approved but never used H-1B petition to transfer to a different company? So they have an approved H-1B from 2010, but they have never used it. So the problem is not so much here that you have an unused H-1B. The problem is it is very old. It is 11 years old. So normally you could, and USCIS has told us they don't like to allow us to use an H-1B unless it has either received a change of status or you have obtained a visa. Mere approval with consular processing is not enough. However, we have been able to get successful H-1B quota opt-out as long as the case was approved. So what they say and what they do may be two different things. My problem is this is too old. You may want to look into something called remainder option. So if you went outside the United States for 1 year after you got the H-1B, which is, I believe, what happened in your case, you might be able to get the time remaining on your H-1B without regard to when it was approved. So you look into remainder option. That's the only thing I can think of. Impact on H-1B status, that's the next question. Impact on H-1B status of using advanced parole. So I'm not worried about the fact that you use the advanced parole to return. If you come back to resume the job that was your H-1B job, even though you entered the United States on advanced parole this time, you are still considered to be holding an H-1B status. That is not disturbed by your exit and entry with advanced parole. This has been on the books for a long time. So we know that would work out fine for you. And even though the I-94 that you get with the advanced parole entry is limited, it should not be a problem. You should be able to transfer employers. You definitely can amend or even extend your H-1B within the United States. I'm not aware of any limitations, at least I don't remember there being any limitation on the ability to use the H-1B for a transfer. And yes, you can always reinstate any H-1B if you have, for example, used your employment authorization. So if you use an EAD, now you're on EAD, let's say 3 months you work on EAD, then 3 months later you decide, I want to convert back to my H-1B. All you have to do is, if you already have time remaining on your H-1B, and if you have an existing H-1B stamp, you can just go outside and come back using your H-1B visa. You are back on H-1B. The EAD is no longer interrupting your H-1B. If you don't have a visa stamp, you can go get an H-1B visa and come back. If your H-1B has expired, you can seek a renewal of the H-1B through the USCIS, then go outside USA, get an H-1B visa stamp and come back. And you can go to any country, not just your home country. So yes, you can always revive an H-1B. Let's see what other frequently asked questions we have. So travel to India on H-1B status, stamping was done through national interest exemption or exception. The job contract ended getting back to the United States. First of all, remember, unless you have a specific job in hand, the one that has been described in the H-1B, you should not be using the H-1B to come back. So let's say your employer had placed you at project XYZ, but then you left the United States and you got stuck in India or whichever country, and you're not able to come back to project XYZ because that has been reassigned to somebody else or the end client took that away. You should not enter. What you should do is, if there is another project, ABC, have the employer file an amendment to transfer you from project XYZ to ABC. Once that amendment is approved, you should be able to use that amendment approval from the USCIS and the existing visa stamp on your passport to enter the United States. So do not come back using an H-1B approval / visa which is based upon a project that is already over. Next frequently asked question deals with changing jobs shortly after a promotion with an I-140 approval, I-485 pending, and the 180-day AC-21 portability rule. So you want to move using AC-21 right after you get promoted, and I don't see any problem because remember, there is possibility of self-portability as well. So let's say a company, let's call it XYZ, petitioned your green card, you did the perm, you did the I-140, 485 is pending, and you got promoted from your green card job, which was software developer, to a higher title, let's say delivery manager or software manager. Is that a problem? Well, technically, this is not the job for which your green card is being processed. But because you are protected by the AC-21, I-140 having been approved, 180 pending, you can take a similar job. It doesn't have to be the same job. So software developer to software delivery manager or software manager is a similar job in all probability. So if you can self-port to the same job, I don't see any reason why you can't move to another employer. But of course, Sarah, you should have your lawyers review the two job descriptions and make sure they are same or similar. Next question is, STEM extension application is pending with the USCIS due to a USCIS error in failing to withdraw the H1. So you are on OPT, you filed for STEM extension, but H1B was pending withdrawal at Texas Service Center for the last 6 months. They have not acted, but the government is holding on to your STEM extension. What can I do to resolve this? Well, first thing you should do is you should talk with your DSO, see if your SEVIS can be fixed with just a data fix. I'm not sure it can be, but it's worth asking them. Since it's taken so long, normally what happens is when you have an H1B with a change of status request, the DSO gets notification and they invalidate or inactivate your SEVIS. And that can be a part of a problem why your STEM extension cannot be granted. But many times the DSOs are able to fix this problem with a data fix. So first thing I would do is talk with your DSO. Second thing I would do is talk with your congressman's office, because even the ombudsman, even though they are effective in my opinion, they can take time. So those are the only two steps that I can recommend in addition to what you've done. Let's see if there are any other frequently asked questions. There are none. So now let's go back to regular questions. So there are some issues with the spouse's birth certificate, name, etc. Here is what you can consider. You can consider doing a formal name change in the United States. Okay. So how does that work? Typically, it's different from state to state. In most states, you will contact the local court system at the lowest level, ask them how to process a name change. They will tell you what forms to fill out, etc. You don't need a lawyer for this in most states. The forms are pretty self-explanatory. They tell you where to place an ad, etc., provide the proof to the court, and the judge in the court will actually enter a change in name, that Miss Mary Jane has officially changed her name to Mary Higgins or Jane Higgins or whatever the name is. Okay. Now, using that, that's the evidence. Using a certified copy of that, you can get all the documents, but not the visa. The visa would still have to be, next time when you go for visa stamping, you can show the court change and the name change documents, and they will issue the next visa in the changed name. You will have to change the social security number, the driver's license, as well as the passport. Only thing I do not know how difficult it is for the Indian government to accept that name change. American agencies, all of them will accept that. Okay? Good luck. Okay, let's see if there is any other question. Okay, degree equivalency for EB3 professionals, EB2 to EB3. See, one of the biggest problem with a 3+2 year degree pattern, which is common in India, BSc and MSc in computer science, it can be a problematic issue for getting an EB3, because EB3 doesn't allow you to combine degrees. Sometimes in the past, we were able to get a degree evaluation for only masters, and single degree evaluation brings you to EB3. But EB3 actually does not require even a degree, just 2 years experience. But it all depends upon the language of the perm. In your case, it is master's degree with 6 months. Now, because you have a 3+2 pattern, chances are the government sees that they'll probably revoke your EB2. I hate to tell you that, but that's a definite problem. Okay. And education plus 5 years of work experience doesn't quite qualify. I don't know how it got approved, but it appears to me that even your EB2 is questionable. So I think you're going to have a problem. I think it's very difficult to get this case approved. I think that they can go after your EB2. Our next question deals with when AC21 kicks in when you are downgrading. And the answer here is if your I-140 is still pending, you are not AC21 eligible yet. So the law says I'm eligible for AC21 once I-140 is approved and I-485 has been pending 180 days. So let's say my I-485 has been pending 200 days, but my I-140 is not approved. I am not AC21 eligible. I'm not protected yet. But let's say on the 200th day, my I-140 gets approved. Now I am immediately AC21 eligible because my 485 has been pending 180 days. So the rest of the questions are redundant. Is it safe to travel in such circumstances? I certainly think so. And we have discussed what happens to the H-1B when you travel on advanced parole in this conference call. So you can take a look at it. It is possible to add your spouse to your green card process. If she comes back on an H-4 with you, she can be her 485 can be filed only if her dates are current. Okay, so that's the way it would work. Can I change employers with twice approved I-140 in EB2 category? So your priority date 2013, I-140 is approved 2 times with different companies, 20 years of IT experience. So the question is, your I-140 have been approved twice. Now you want to change the technologies that you work with. So when you move to the new company with the new technology, they will start your green card again. I think that's what you said. Give me 1 second. Yes. So leaving aside what experience you can use and what experience you cannot use, which is the second set of or second tier of inquiry, and your lawyer should be handling that, not me in a generic format. But let me tell you this. There is absolutely no problem with an employee changing technologies. That does not impede the carryover of the priority date. Okay, so let's say I was a .NET developer. I got an I-140 approval as a .NET developer. Then I got another I-90 approval as an Oracle developer. And now I'm an SAP. I want to get into SAP. Do those priority dates get disturbed if a new green card is started? Not at all. Technologies can change. That has nothing to do with it. Next question. Let's see. We covered these frequently asked questions. So changing employers after H-1B was approved under consular notification. You have your H-1B approved under consular petition from Company A. You are in the United States on F1 optional practical training. Can you transfer your H-1B without leaving the United States? I guess that's what you're asking. And I have answered this question earlier in this call today. I believe that you can. The government may not like it. USCIS has said that unless you get a visa stamp or a change of status, you are still stuck with H-1B quota, but we have received plenty of approvals, especially if the current company, which is company A, are not going to revoke your H-1B. I think it'll be a good idea to argue that you can, and I think you can transfer companies. You'll have to apply for a change of status this time when you do. I think the government will not be able to object to it. But that's my take on this. You can double check or have your employers double check with the USCIS, whatever that is worth. Okay. Next question is about N-470 application to preserve residence for naturalization. It looks like you have stayed outside the United States past your re-entry permit. Oh, I think you need to worry about it because it appears you have not established your permanent residence in the United States, or at least if you had established it, you have abandoned it. This is a serious situation. You should definitely talk to a lawyer, understand what your limits to your right to stay outside the United States or allowance to stay outside the United States is. You can apply for your wife a family-based green card while you're still outside the United States. That's not a problem. The way I read the law and the way we have done it in the past is before her green card interview at the consulate, when her papers get processed, just make sure that you can establish to the satisfaction of the US consulate that you have either moved back or you are in the process of moving back. Okay. Now, if you have a child, they can come with you before the age of 2. That's not a problem. If the child is born before your wife is interviewed, they should be added on by the consulate and they should get their own green card. I think you definitely need a consultation. You have several issues here, even about the N-470, which I don't think is being handled correctly. You definitely need to talk to a lawyer in detail. You need to understand how your green card can be taken away at the moment because it appears that your re-entry permit is already gone. Okay? So talk to your lawyers or talk to a lawyer outside your firm. I think somebody needs to look at your paperwork and your entire situation and then give you advice based upon your particular specific circumstances rather than generic. Okay? Good luck. Thank you, folks. These were all the questions we had today. And I'll see you again in a couple of weeks or whenever the team sets us up.